So based on that same question, so let's assume I come into your office and how do you prepare a client like me, maybe let's say non-attorney and an attorney, maybe the two you can compare and contrast. Like, what do you tell a client when you're doing an intake? What are you trying to get a sense of when the person comes in? I guess maybe how are you setting up their expectations? Maybe that's the question I meant to ask.
Well, uh, another very good question. It's you want to learn as much as you can about the facts of the case so that you have an idea both as to whether there's merit to the claims, if it's a defense, what kind of defenses that person or company may have or not have. And you also want to have an idea of the timeliness of it because there are statutes of limitations. So these are the types of things you want to know off the bat. But another thing that I at least believe it's important to advise potential clients up front is that litigation is an expensive process. Unless an attorney is willing to take something on a contingency basis, and there are very limited circumstances under which something like that can happen, where a firm will take something on a contingency. It has to either be along the lines of a personal injury case or something like, or maybe even an employment case, depending on the circumstances, or something where there is a very strong possibility of a recovery. In other cases, though, you're not really going to see too much by way of contingency. So it's important to let clients know that it's going to be an expensive proposition, but you also have to let them know that you're going to be handling the case appropriately. And by that, I mean, you're going to handle a $4 million case much differently than you're going to handle a $100,000 case.
Right.
There are just things you will and won't do. And it's a matter of managing how that case is going to go forward as best as possible in order to keep the case affordable for the client, unless the client has unlimited resources and doesn't care, which doesn't happen very often.
So what if do you get the righteous clients that says I don't care, I'm right, and I don't care how much it costs, and how do you caution them? How do you handle a client like that, or someone with unrealistic expectations? Let's just say.
Right. Well, you want to let them know from the outset, and certainly as the case develops, because there are always clients come to you and you try to get all the information from them that you can, but throughout the course of litigation, there invariably are going to be new facts that you're going to learn. And so it's a matter of trying to understand how those new facts are going to impact the case as a whole, and to give your client an understanding as you go along as to how that changes your handicapping of the success of the case. So that's something you want to talk about. And in the situation you brought up at the beginning, if you have a client with unlimited resources and they come in and they say, I'm going to stand on principle, I don't want to settle, I want to take this all the way, you need to, first of all, have them understand what that means and how that's going to play out, how long it's going to play out. And you need to have them understand that there are things you can do and you can do ethically, and then there are things you cannot do and will not do in pursuing the case. So it's important that they understand what's possible, but that there are limits to what's possible.